Let's talk about intrinsic evidence first. Intrinsic evidence means the words on the page, often referred to as the four corners of the contract. And the restatement again reminds us that the first principle in contract formation is ascribe to the contract the meaning intended by the parties. We interpret the words through the lens of what these parties either actually or reasonably thought about the bargain they were striking. We have a series of rules, such as they are, I call them canons, which help us use specific rules of grammar in a systematic way to derive reasonable, common sense meaning. These canons of construction signify how people would reasonably think about written terms, and therefore is a way of understanding the intrinsic terms through reasonable common sense. And accordingly, these are sort of common rules that people share about how language is used. As a reminder, in this class, I've identified 13 plus 1 canons, the 13 semantic canons and the canon of construction. I really invented that number. There's no specific number of canons. But for our classroom environment, we can use these as if they were rules and number them accordingly, just for our shared understanding and for our local purposes. But in fact, there are many canons of construction. The restatement recognizes some of them, and there are others recognized elsewhere. The restatement discusses some of those canons in sections 202 and 203. It talks about what to prioritize and that words and conduct should be interpreted in light of commercially reasonable circumstances. There's a particular wonkiness to usage of trade. If you think back to the slide where I presented the 7 types of evidence, usage of trade was fairly low at 6, and in fact, in other places it's identified as less preferable than course of dealing or course of performance. But usage of trade is interesting because it actually shows us the semantic meaning of a term, because the parties in a trade are expected to be using that term in line with its trade usage, in line with the way that that term is used in trade. And so trade usage has this unusual place of being both the lowest of the types of extrinsic evidence, but also possibly shedding light on the intrinsic evidence of a contract, because it tells us what parties probably intended when they used a certain word, provided that they were in that trade. If they were in that trade, we find it likely that they were using that word in line with the usage of that trade. The restatement smushes the concepts of course of dealing and course of performance into Rule 223. In short, the restatement would liberally admit evidence, extrinsic evidence particularly. But note, in Pennsylvania, courts are more conservative. They are less likely to admit extrinsic evidence, as we'll come to. The UCC is even more liberal than the restatement in the admission of extrinsic evidence. In fact, by, I think, a good reading of UCC 1-303, extrinsic evidence of course of performance, course of dealing, or uses of trade is nearly always admissible to prove the meaning of a contract for the sale of goods. And the restatement has an example which I modified, which shows how this idea of extrinsic meaning can be applied to the intrinsic terms, because it's the zeitgeist. It is the atmosphere in which words are used. And so that usage of trade can tell us what is a reasonable interpretation of terms used by the parties. Sometimes courts push this to its outer limits. Maybe that's because usage of trade shows that it's actually harder than it seems to distinguish between intrinsic and extrinsic evidence. And perhaps some courts simply go too far, as may have happened in the case of Nanakuli Paving, where the contract clearly stated in express terms the price should be the price at the time of delivery, but due to course of performance and usage of trade, the court found that what that actually meant was price at the time a bid was made, something called price protection. And so Nanakuli is an example of courts going quite far away from the intrinsic evidence, maybe because they feel they can understand the intrinsic evidence, the words on the page, better by having a clear understanding of the usage, the way parties use those words. Again, Pennsylvania courts take a more conservative approach to admission of such evidence. And finally, if after we've gone through the process of applying the canons and trying to disambiguify the contract, we still might not have a clear meaning. The canon or doctrine of contra preferentum, construction against the drafter, means a court can simply disperse with the pursuit of meaning and choose the interpretation that suits the underdog, that suits the party with less bargaining power, that suits the non-drafter, and rule in favor of the party who is less powerful, perhaps creating an incentive to draft contracts well.